If that catchy new tune on the radio sounds familiar, there could be a reason. David Pogue tells us about the fine line between inspiration and infringement.
You want me, I want you, baby. My sugar boo, I'm levitating.
This Dua Lipa song, Levitating,
I got you, moonlight, you're my starlight. I need
has now been on the pop music charts for 72 weeks in a row. But a band called Article Sound System is suing her for stealing one of their songs. The two songs have the same key and tempo, same melody, and same chords.
He's so fine.
These lawsuits have a history. The first big one to go to trial was the Chiffons
One with the wavy hair.
versus George Harrison.
my sweet Lord.
Harrison lost and paid over $500,000. Now the thing is, when you write a song, you only have a certain number of notes to choose from. And most songs use only a few chords. So inevitably, sooner or later, two people are going to write sections of songs that sound alike. Should there even be lawsuits like this? Well,
How many letters are there in the alphabet?
26.
Okay. And how many words can you create out of those 26 letters? Billions, millions, right? So I don't care how many notes there are or how many chords, there is an infinite number of ways to mix those notes up, to mix those chords up, to create original music.
Lawyer Richard Bush has sued several famous bands for stealing, and he's won every time.
Everybody get up.
Including in the Blurred Lines case.
It was a nightmare. I lost a lot of faith in people and their motivations in the music business.
Maybe I'm going deaf.
To Jan Gay, the 2013 hit Blurred Lines sounded an awful lot like a 1977 song called Got to Give It Up by her ex-husband, Marvin Gaye. No one needed to convince you of how much it sounded like Got to Give It Up.
Not for a moment. I was there when Marvin made the record, so there was no hesitation, no confusion.
Richard Bush won the case. The Gay family got $5 million and half of all future royalties. What made the Blurred Lines case notorious is that the songs aren't technically that much alike. The melodies and lyrics are different. The chords and bass lines are different. What they do have in common is their vibe, the beat, the cowbell, the party chatter. The verdict seemed to open the doors for similar lawsuits against famous bands.
How did you find me?
Martin Harrington and Thomas Leonard sued Ed Sheeran
So you can keep me.
and won co-writing credit and royalties. Now, to win one of these lawsuits, you have to prove three things. First, you have to prove that you own the original song. Second, you have to prove that the thief had access, that they heard your song at some point. And finally, the big one, you have to prove that the two songs are substantially similar. And that's where things get tricky.
No one can own individual notes. No one can own chord progressions. No one can own a guitar riff. No one certainly can own a feel of a song.
Lawyer Eileen Farkas has represented songwriters who are accused of stealing songs. She argues that there's a difference between copying and inspiration.
The Beatles were inspired by Bob Dylan, the Rolling Stones by the great Delta blues artist and Robert Johnson, Elvis by B.B. King. They put their own spin and modern day approach to it, and that's what creativity is about.
On this hard drive is 68 billion melodies that arguably include every melody that's ever been written and every melody that ever can be written.
Damian Reel is a musician, lawyer, and programmer. He and a friend wrote a software program to generate those 68 billion melodies to make the point that suing over a snippet of a song is absurd.
What we've done is taken all of these songs, all of these melodies, and placed them all in the public domain so that anyone could be able to use them freely without having to worry about getting sued.
How far would you go with this thought of these lawsuits are silly? Like, I just wrote a song that goes, Saturday, all my Dalmatians seem so far away. Like, is that okay?
Absolutely not. If someone steals an entire song, yes, sue those people for all they're worth. But for very short phrases of melodies, and perhaps even longer melodies, they should not be copyrighted.
Eileen Farkas isn't sure that hard drive full of melodies would hold up in court, but maybe the stunt made its point. In more recent lawsuits, the pendulum has begun swinging back.
I feel like there's been a bit of a course correction in the cases that have followed Blurred Lines.
When a band called Spirit sued Led Zeppelin in 2014, they ultimately lost. And when a rapper called Flame sued Katy Perry in 2019, he lost on appeal too. The judge wrote that those 8 notes are not a particularly unique or rare combination.
Those are 2 great examples of courts that said we're not going to start dissecting music and hunting for similarities so that we can hand out ownership to pieces of music. No one wins if that happens.
I need you all night. Come on, dance with me. I'm levitating you.
And so, in the Dua Lipa case, what would you decide if you were the judge? Richard Bush knows what he thinks. There are people who believe that there shouldn't be any lawsuits over copyright infringements, that good artists copy, great artists steal, that we build on existing works.
People who say that probably haven't had their stuff stolen.